5 seconds to go. Start. Writ petition number 11934 of 1995 brings in the next appeal, which is CA number 7334 of 2013. The above writ petition was filed by Messrs. Kaya Ram Hotel Private Limited. The challenge in the said writ petition was to the very same rule. The case set up in short is as follows. The petitioners are the owners of about 62 grounds. It applied for the sanction of a building plan in the year 1975 for the construction of a hotel. There is reference to an earlier writ petition and contempt proceeding. Suffice it to notice that planning permission was granted after a delay of 12 years on 8th September 1992. It is their case that it was faced with certain difficulties in the construction. A revised plan was submitted and building permission was sought for on 17th August 1994 for the construction of a hotel and hotel annex building etc., which consisted of a basement, ground floor and 3 further floors. By letter dated 13th September 1994, issued by the second respondent, the petitioner was to gift the open space reserved area to the Commissioner Corporation of Madras. We may notice further that the third respondent sent communication on 1st December 1994. It is stated inter alia that the structure which existed within the OSR area should be demolished after due sanction and that the OSR land should be free from any structure and be fenced by providing separate entrance from the roadside. There is no mention about the gift deed. The petitioner sought a month's time to comply with the conditions in letter dated 1st December 1994. However, the respondent insisted on compliance with the requirement of executing a gift deed. In the writ petition, an interim order dated 13th March 1996 was passed directing permission after recording undertaking by petitioner to execute gift deed without prejudice to the rights of the petitioner. Petitioner executed gift deed on 22nd May 1996. Petitioner's revised plan was approved as a group development on 24th April 1999. The grounds urged against the rule appear to be as follows. The rule is an illegal infraction of the petitioner's right to hold and enjoy the property. The rule is contrary to the Act and derogatory to the interest of the landowners. The stipulation is violative of the civil right vested in every owner of the property to hold his land, and the right to safeguard public interest cannot be stretched to create a right and title in favor of a local body in the manner contemplated by the respondents 1 and 2. It could only impose a condition to keep such land as open for being used by the user of such building for their communal or recreational purpose. The provision for open space with respect to a special building is for the communal and recreational purposes of the people who shared their accommodation in the said building or otherwise lawfully use the same. It is not intended to take away the proprietary right of the owners. The expression of willingness by the petitioner to provide the stipulated open space reserved for communal and recreational use of the occupiers will satisfy the public interest and object of the legislation. Petitioners undertake to keep 10% of the area to be developed, excluding roads, as open space for communal and recreational purpose. The further condition imposed by the third respondent to provide exclusive frontage for the said open space area opening into the main road is unconscionable in law and contrary to the spirit of the Act. Such stipulation is in terrorem. Stop.